My name is Siavash. I'm from C-File, and it's a pleasure to be here with you and all the participants. I'd like to welcome everyone to another webinar by C-File. Today, the topic is about the future of international law, and we have two great speakers, Dr. Poorhashemi and Dr. Masulu. I'd like to talk about C-File first and introduce that one and go to the speakers. So C-File is an independent, non-political and private institute working with groups of international lawyers and scientific experts across the globe to promote the implementation of national and international law. C-File facilitates access to justice and legal professionals around the world and provides legal services, including but not limited to international law expertise, contract law, immigration, finding a lawyer in a different country, online courses, publications, and Journal of International Law. C-File is headquartered in Toronto, Canada. Right now it's about 10:01 a.m. and it works closely with many national and international lawyers around the world. So today we are going to start the webinar with Dr. Poorhashemi. I'd like to introduce him to you too, and then we will listen to him. Dr. Poorhashemi is the president of the Canadian Institute for International Law Expertise, in brief C-File, and an expert in international law. He has received his postdoc in international law from Canada, and he is providing legal opinions on international law as an expert before the foreign and Canadian courts. So, his teaching and research interests are in the areas of public international law, international criminal law, and international environmental law. He has published many books and articles in each of these areas. He is also the editor-in-chief of the C-File Journal of International Law, or in brief, CJIL. So, thank you again for joining us in this webinar. I will ask Dr. Poorhashemi to start, and we're going to enjoy his speech in public international law challenges and opportunities. Dr. Poorhashemi, please.
Okay. Hello everyone. I don't know. It's
Yeah, we can hear you, Doctor.
Okay.
Yeah.
Hello.
We can hear you, President.
This is a great pleasure to see you all in this webinar on the future of international law. I would like to thank our scientific members, specifically Professor Srivansulu, Professor of Law at National University of India, for accepting to be part of this webinar as a speaker. On behalf of the Canadian Institute for International Law Expertise, I would like to welcome you all today, as well as C-File's members, lawyers around the world, and other distinguished participants in this webinar. At this historical moment of COVID, I would share with you a challenge and opportunity of international law to show you a different picture of view of international law. In fact, thinking and rethinking about the past, future, international law will help us to define our place in international law practice, because both national and international law cannot be so easily separated each other. We are witnessing an extremely serious situation which is changing everything in our personal and professional life. In fact, the emergence and spread of COVID-19 has created and still creating health issues, economic challenges, political crisis, and social conflict around the world. These challenges and conflicts leads international community to re-evaluate global governance and international structures, which is based on the Second World War and post-Cold War. The pandemic emerged new era of international law and society. It would not be similar to the pre-coronavirus. In the same way, we are observing in many countries the rise of nationalism, populism, extremist ideologies, human rights violations, and kind of anarchy in the international society. The United Nations in 1945 has established a current international law based on some principles such as equality between states, self-determinations, international cooperation, respect of human rights, and peaceful conflicts resolution in international law. We can see today these principles are transforming to unilateral approaches in practices which lead to the geopolitical tensions and threat international peace and security. The United Nations cannot keep its promise to establish international peace and security, territorial sovereignty, balance of powers, common interest of humanities. The COVID-19 is changing and even damaging the global values, international principle and system that have been fundamental in international governance for more than 7 decades. The Charter of the Charter of UN and the Statute of ICC have defined the current international system. Based off my presentation, I would like to talk about some potential challenges for the future of international law arising from COVID-19. One of the challenges is the threat to global peace and international security. Here, the question is whether COVID-19 could be a threat to international peace and security. Surely the pandemic could affect global peace and security. The pandemic is causing political conflicts in national levels in many countries. Furthermore, coronavirus have a risk of conflict between some states, such as United States and China, India, Pakistan, North Korea and South Korea, and etc. In this situation, the United Nations has a limited authority to manage the global situation. Meanwhile, the multilateralism and international cooperation are essential to maintain peace and security, sustainable development, and human rights in this ongoing situation. The commitment to the peaceful settlement of international disputes is fundamental principle of the Charter of the United Nations. However, the existing world order is changing. Based on this projection, can we predict the pandemic will transfer world into a new order, new global order? The second challenge is economic confrontation. The pandemic could affect the global economic system, both at the level of production, distribution, and in the daily economic life of humans. It reveals certain deficiencies and weaknesses in the global economic financial system. The current world, based on the free market, is changing, and in uncertain situation can increase competition between the states. Confrontation is playing increasing role in international relation between countries. The multiplication of unilateral actions and the extension to the field of high and new technologies, economic sanctions, disagreement in international organizations could only some of the example of confrontation between a state in the future of international law. Another challenge is regarding the augmentation of international pressure for judicial action under the vast human economic loss caused by pandemic. Some individuals and countries are willing to file lawsuit or complain against China or another countries. In the current state of international law, the claimant state or individual is required to prove the negligence or breach of international obligation to this or to receive any compensation regarding defendant state. According to the fundamental of international law, violation of a state international the commission of any international wrongful act engaged international responsibility. Thus, the claimant state or individual should prove that China or other country had violated international obligations. In this case, the potential legal action against each other could be additional competition between states. The Charter of the United Nations and invites some states to settle their international dispute by using peaceful means, including arbitration or judicial settlement. However, the international justice system seems confronted to several limitations and deficiencies. Another challenge, international institution, the global challenges and require global participation and cooperation. The world after pandemic will raise the interest issue of reforming functioning of international institutions such as the United Nations, and more specifically the Security Council. The current composition of Security Council is no longer reflect contemporary international society. The right to veto or reform of permanent members require providing a solution for the functioning of the council and the maintaining the peace and security in the world. The issue is whether we can imagine or dissolve this actual United Nations and establish another United Nations in the post-coronavirus. Besides, the General Assembly of the UN as a most representative and democratic forum has a crucial role to play for the normative and institutional development of international law. The next issue is global issue. The pandemic proves that health issue has no border. In international law, become global health problem. And this fact, national state and international institution can no longer view health as a border issue, as they often did in the past pandemic. The rapid development of communication across the nations through travel and trade has facilitated transmission of the disease to country and to another country. In this context, can we expect the emergence, the development and international health law as a new branch of international law? Also, the virus spread and disease in developed and developing countries have shown that the World Organization leadership has failed to manage the growing trade in the world. In some states, they declare that the effectiveness of the WHO, explicitly at the time of the global crisis. The next challenge is global governance in the context of COVID-19. In fact, the global crisis management regarding the pandemic led to the emergence of new actors in international law, which now plays more predominant globally and in the multi-actor and multi-level governance in the world. In such a situation, some developing countries are willing to have more authority and position in global governance. In this context, COVID-19 is changing the global distribution of power among the states, which could have a fundamentally impact in the international legal and international institutional system. In this perspective, all states should continue to foster multilateralism, collaboration, and cooperation to reduce health issues and to peace, security, and other challenges caused by COVID-19. Then we are also facing environmental issue and concern. The coronavirus and biodiversity are linked together. According to some reliable scientists, the COVID-19 disease started from Wuhan, China seafood market, where wild animals, including remote birds, rabbits, bats, and snakes, are traded illegally. Some of the scientists believe that the new coronavirus genetics is almost identical to the one found in bat. So environmental protection, especially biodiversity protection, is related directly to the pandemic. In this context, international society should continue to contribute the effort to address ongoing challenges, to protect biodiversity, illegal wide trade, waste management, and climate change, of course. Finally, social distancing and work remotely are supporting to determine how social media and virtual communication are crucial for the humanity. Existing international law will transfer into new form of law based on new technology and virtual life. International organizations are working to develop a new model to create a new workplace for their employees and clients. So new technologies change not only international legal institutions, but also international actors' behavior and communication in the world. In conclusion, the pandemic has caused an unimaginable devastation and hardship to the international community. It's changing the substantive and institutional aspect of international law. The outbreak will have lasting economic and political and social consequences in every corner of the globe. International law as a body of law that governs relationship between a state, international organizations, and private persons in a global framework, exposing its vulnerability no one ever existence, which means international law would not be same as before. Besides, the conflict between national sovereignty and global values of the international community, such as environmental protection, sustainable development, and human rights, remain unresolvable. International law must show its effectiveness, its capability of adapting new reform based on the democratization of the international institutions. Such democratizations will help to empower the decision-making process and improve transparency in the world. There are other challenges and opportunities in the future of international law which are remaining for future research and discussion.